Another federal court of appeals has found that the Second Amendment applies to a specific individual who had the misfortune of being convicted of a nonviolent felony. You'll definitely want to stick around for this one because I think you will be shocked by which court issued this victory. Hello everyone and welcome to the Firearm Firm channel. Today we are going to be talking about yet another victory for nonviolent felons wishing to have their Second Amendment rights restored. This time, the victory came out of the United States Court of Appeals for the Ninth Circuit. You heard me right, the Ninth Circuit, which we all know has a history of not being very 2A friendly. But before we dive into this case and the ruling, please take a moment to click on that like button and don't forget to hit the subscribe icon located down in the right hand corner of this video to subscribe to the Firearm Firm channel. By liking and subscribing, you are letting YouTube know that the Second Amendment is not a second-class right. The case we're looking at today is the United States versus Stephen Duarte, aka Shorty, and yes, that's the actual case title. So back on March the 20th of 2020, two Inglewood police officers observed a vehicle run a stop sign, and when the officers activated their overhead lights, they observed the rear passenger, later identified as Duarte, roll the window down and throw out a handgun. A search of the vehicle recovered a loaded magazine, which of course fit perfectly into the magazine well of the recovered handgun that was thrown out the window. Subsequently, a federal grand jury indicted Duarte for possessing a firearm while knowing he had previously been convicted of a crime punishable by imprisonment for a term exceeding 1 year in violation of 18 U.S.C. 922 G1. The indictment itself referenced Mr. Duarte's 5 prior non-violent criminal convictions from California, which consisted of vandalism, felon in possession of a firearm, possession of a controlled substance, and 2 convictions for evading a peace officer. A jury did ultimately find Mr. Duarte guilty and he timely appealed, but at that time he did not appeal his conviction based on a Second Amendment violation. Later on he did, and the government tried to argue that his Second Amendment appeal was untimely and should be dismissed, but the court found that there was a good cause exception for the late appeal based on the ruling in the United States Supreme Court case of New York State Rifle and Pistol Association versus Bruin. The ninth reason that at the time Duarte filed his original appeal, there was no reason to challenge his conviction under the Second Amendment because there was already a controlling case out of the Ninth Circuit finding that 18 U.S.C. 922 G1 did not violate the Second Amendment, and Bruin was decided after the time period for Mr. Duarte to file his appeal. Now, a vast majority of the 74-page order is discussing legal procedure about why the Ninth Circuit is deviating from their prior precedent based on the Bruin decision, so I'm not going to get into all that. But I will put a link to the entire order down in the description section, so please feel free to read it if you feel the need to. So in the order, the court wrote, Step 1 of Bruin asked the threshold question, whether the Second Amendment's plain text covers the individual, the type of arm, and the proposed course of conduct that are at issue. Here, as in Bruin, it is undisputed that the Second Amendment protects the arm in this case, which is a handgun, and the conduct involved, the simple possession of that handgun. All that is left for the court to decide is the first textual element, whether Duarte is among the people to whom the Second Amendment rights belong to. The court quickly did determine that Duarte was among the people because he is an American citizen, which is what the United States Supreme Court had said in the Heller decision. In Heller, the United States Supreme Court held that the people include all Americans because they fall squarely within our national community. The government turned to some historical analogs to try and demonstrate that the ban on felons possessing firearms is consistent with the nation's historical tradition of firearm regulation. In the order, the court noted, because bans on convicts possessing firearms were unknown in the United States before World War I, the government must identify for us a well-established and representative historical analog to 18 U.S.C. 922 G1 that can justify the law's application to Duarte. In assessing whether the government has met its burden, the 2 central considerations that guide our analysis are how and why. The government's proposed analogs burden the Second Amendment right. Did these historical examples, we must ask, impose a comparable burden on the right of armed self-defense that was comparably justified, Bruin's why, as compared to Section 922G1. One final point of order. While the government does not have to find for us a historical dead ringer to 922G1, a law that remotely resembles a felon firearm ban is not enough. We are looking for something in between these two endpoints. On that score, Bruin offers some additional guidance. If the law at issue is distinctly modern firearm regulation because it addresses a societal problem unimaginable at the founding, the government's historical analogs need only be relevantly similar to the challenged law. The court then went on to explain that Section 922G1, however, takes aim at gun violence generally, which is a problem that has persisted in this country since the 18th century. And Section 922G1 confronts that problem with a flat ban on possession of guns by the formerly incarcerated, which no one here disputes is something that the founders themselves could have adopted. Thus, the fact that the founding generation had no laws limiting gun possession by people convicted of crimes, while not fatal to the government's case, means that the lack of a historical regulation that is distinctly similar to 922G1 is strong, if not conclusive, evidence that the law is inconsistent with the Second Amendment. Why? Because states in 1791 and 1868 also grapple with general gun violence. California must provide analogs that are distinctly similar. We turn now to the government's evidence. The government attempted to meet its burden by first using non-firearm regulations per se, but a trio of draft proposals that certain members of New Hampshire's, Massachusetts, and Pennsylvania's state convention recommended adding to the Constitution prior to its ratification. Needless to say, the court did not find this very persuasive at all. The government next then offered early 17th to early 19th century colonial and American laws that disarmed groups from the founding generation such as British Loyalists, Catholics, Indians, and blacks. But the court found these type of restrictions far less reaching than 18 U.S.C. 922G1. As to this argument, the court wrote, in sum, the burdens and justifications, Bruin's how and why, for laws disarming disfavored groups at the founding are not distinctly similar to 922G1 to justify its blanket ban on nonviolent felons possessing firearms. Courts should not uphold every modern law that remotely resembles a historical analog because doing so risks endorsing outliers that our ancestors would never have accepted. Lastly, the government argued that the founding generation would have understood that the 18th century felon had no right to possess a firearm because historically he faced death and total estate forfeiture for his crimes. And since felons at the founding were punished this harshly, the government contends it is consistent with our nation's history to disarm permanently the modern day felon because that is far less severe of a penalty. The court once again rejected this line of reasoning of arguments made by the government, writing, first, the history of punishing felonies at the founding is far more nuanced than the government lets on. The notion that all felons, violent and nonviolent alike, were historically put to death or stripped of their estates is shaky to begin with. Second, today's felon in many respects resembles nothing of his founding era counterpart, despite bearing the same label. As indicated in the beginning, the court determined that the government failed to meet its burden under Bruin and found that 18 U.S.C. 922 subsection G1 did in fact violate Duarte's Second Amendment rights, and therefore it is unconstitutional as applied to him. However, the court did write, we do not base our decision on the notion that felons should not be prohibited from possessing firearms. As a matter of policy, Section 922G1 may make a great deal of sense, but the very enumeration of the Second Amendment right in our Constitution takes out of our hands the power to decide for which Americans that right is really worth insisting upon. Even though this order is only applicable to Mr. Duarte himself, it is still a victory for nonviolent felons everywhere. The Ninth now joins the Third Circuit in finding that the permanent ban on possession of firearms by nonviolent felons does in fact violate the Second Amendment as applied to specific defendants. The 7th, 8th, 10th, and 11th circuits all have rejected constitutional challenges to Section 922G1, either as applied to particular parties or categorically. Thus, we have a split among the circuits, which eventually should get the attention of the United States Supreme Court. So we're going to have to wait and see if and when the U.S. Supreme Court is going to step in and resolve this issue. Be sure to let us know what you think about this ruling down in the comments section below. You can also leave any questions you have about this video or any other Second Amendment related question there too. Or you can email your questions directly to us at questions@thefirearmfirm.com. Until next time, stay armed and educated.